now have law professor and constitutional law book author, Attorney Jennifer Arlene Reyes. Good morning, Attorney, and thank you for joining us here on News and Views.
Good morning to you, two beautiful ladies.
Just like you, Attorney, no? But let's go to our top story this morning, the delay in the impeachment trial. What do you make of Senate President Cheese Escudero's judgment call to further delay this impeachment trial once again to June 11? Does his argument hold water, or do you think this is already a deliberate delay or going against what the Constitution mandates?
Yes, I believe, well, with utmost respect to Senate President Cheese Escudero, our Constitution is clear. It is unambiguous. The trial before the Senate shall forthwith proceed, meaning it must not be with delay. It must be without delay. It must immediately proceed and continue. So to further postpone these impeachment case, well, in my humble opinion, it violates the constitutional mandate provided by the highest law of the land.
Attorney, but you have Senate President Cheese Escudero saying they want to prioritize their legislative bills, right? They're trying to pass all these priority bills before the 19th Congress ends. But they will tackle, supposedly, this impeachment complaint by June 11. What does that indicate? I mean, you have the Senate President saying, of course, their duty as a Senate is to legislate bills. What does that? How are you reading this move?
Well, with respect to that opinion by Senate President Cheese Escudero, what I can say is that, of course, their primordial duty is to legislate. But when they say that their primordial duty is to legislate, it should not exclude their other duty, which is to be an impeachment court, which already they are. They are now the judges of this impeachment case. So by saying that their primary duty is to legislate laws, it does not mean that it is the only thing that they should do, especially if an impeachment case like this one is an urgent matter. And I believe it is also provided in their Senate rules, specifically under their Senate rules, that if the Senate schedule is full, but there is an impeachment case which is pending, they must prioritize the impeachment case.
Attorney Reyes, what's your take on some of our lawmakers saying that because the 19th Congress is ending, then there's no reason for them to actually push for the trial right now, since there is or could be a possibility wherein the 20th Congress would say, okay, maybe at the end of the day, we should not push through with the impeachment?
Okay, that's a good question, darling, because there is a confusion between the adjournment sine die of the 19th Congress and the term of the 19th Congress. So we must differentiate the two. When we say that the 19th Congress will adjourn sine die on June 13, it means that what will terminate are only their legislative functions, their legislative works. However, it does not mean that the 19th Congress will also cease. The 19th Congress, meaning they are still senators, they are still members of the House of Representatives until June 30 of 2025. And remember, this is also important to our countrymen who are listening right now. If it is a non-legislative function, which in this case, the impeachment is a non-legislative function, it can continue even after the adjournment sine die of the 19th Congress, because the adjournment only speaks of the termination of the legislative functions. To further simplify, since the impeachment case is a non-legislative function of the Senate, then it can continue even after June 13, 2025, until June 30, 2025.
Yeah, you're right, Attorney. I mean, you also have Senator Coco Pimentel citing the Constitution that under Article 11, senators would be acting as an impeachment court to hold public officials accountable. So that means they should continue their duty to continue with the impeachment trial in the 20th Congress and not base it on Article 6 kung saan back to zero yung kanilang legislative agenda, right? In the 20th Congress. But how crucial is it to trigger this process by June 11 before they adjourn on June 13?
Well, how crucial is it? It is quite crucial. Actually, since February, the time during which the articles of impeachment were transmitted to the Senate, they should have commenced already with the trial. Because the Constitution, just like what I mentioned a while ago, it is clear trial shall forthwith proceed. Well, as to the clarification, because there is also a question whether the 20th Congress also have jurisdiction with respect to this impeachment case, even if it is the 19th Congress which initiated the said impeachment case. In my humble legal opinion, there is no legal impediment why the 20th Congress can also continue with the impeachment case. To further simplify, the 20th Congress can continue this impeachment case against Vice President Sara Duterte because we have a Supreme Court decision. They only need to read the categorical ruling of the court in Pimentel Jr. versus Joint Committee of Congress. This is a 2004 case. The Supreme Court ruled therein that the membership of, a certain committee, well, in this specific case, the Senate, it may change. The membership may change. But if they are, performing a non-legislative function, they will retain their authority even if the new Congress commences. So in this particular case, even if the 20th Congress will commence on June 30 onwards, then they can continue and they still have the authority. I heard the statement of our esteemed Senator Tolentino. I know that he means well, but in my humble opinion, such interpretation of the law is incorrect. There is no impediment, and the 20th Congress can validly, actually, it has validly acquired jurisdiction already because it retains its authority, it retains its jurisdiction. Only the membership may change in the 20th Congress.
Attorney Reyes, if you have already read also, former President or Senate President Franklin Drilon also made a statement saying that this delay by the Senate to proceed with a trial is questionable. And according to him, if they want to, they can actually finish everything by June 30. What do you make of that? Is that even possible?
Yes, I mean, in layman's term, if there's a will, there's a way, right? But with respect to its legal aspect, in interpreting the Constitution, our senators, our legislators must always be reminded that every word of the Constitution was placed by the framers with a particular purpose. Hindi yan nilagay lang ng framers natin because of capricho or dahil pampaganda lamang. When the framers of our Constitution states a certain word, it has a profound and specific purpose. And no branch of government must defy or must disobey such constitutional mandate. It is a basic doctrine in constitutional law that even a congressional enactment, and this includes statutes or even their Senate rules, cannot trump on any constitutional mandate. So I agree with former Senate President Drilon with respect to that matter.
But attorney, here's what's interesting. You have Senate President Cheese Escudero using phrases like "if at all." So that begs the question: is there even an option for the senators not to conduct this impeachment trial, not to proceed? Can they do a vote and just say, let's dismiss this trial? It's no longer a priority in our agenda.
That's a very good question, right? Because, as a constitutional law professor, of course, this subject matter is very close to my heart. Because the Constitution is the supreme law of our country, the highest law of the land. Even our highest officials cannot, defy what the Constitution says. If the Constitution says that the trial by Senate shall forthwith proceed, it is non-negotiable, in my humble opinion. Obey the Constitution first, then also under the Constitution, they are permitted to promulgate their own rules with respect to the impeachment trial or impeachment case. So commence the trial now and then promulgate rules with respect to the impeachment later. I mean, they have all the resources. In my humble opinion, they have all the resources, they have all the time. So there is no reason why further delay must be done with respect to this impeachment case.
So, Attorney, delaying these proceedings or the proceeding could already be a violation of the Constitution, correct? As of like in this present time that we have already pushed this to a later date, they are somehow violating already the Constitution.
Well, in my humble opinion, yes, there could already be a violation of the Constitution. It is quite evident. That is why I also appeal to our good senators to obey the law, obey the highest law of the land. It is, it is your responsibility to the Filipinos to respect the Constitution and, respect the institution itself, because they will also be judged by the people with respect to their leadership, their political will. So I hope they will also follow the Constitution.
Right, because where's the accountability on, on that, since again, it is the mandate of the Constitution to immediately start the proceedings. Senator, if you can Attorney, if you can walk us through very quick. So what happens on June 11? June 11 is the start. They're saying the articles of the impeachment will be read. And then what happens after?
Well, after the articles of impeachment will be read to Vice President Sara Duterte and, of course, her team or her counsels, then the next step generally is, of course, for the Senate to issue certain orders or summons so that it will be sent to, of course, the witnesses, the counsels, and other people who are involved with respect to this case. Also, the Vice President will be given 10 days to submit her answer with respect to these accusations, which is particularly known as the articles of impeachment. And from then on, our senators will take an oath. We call this an oath of political neutrality, wherein they will avow to the Filipino people that as impeachment judges, they will, forget about party or political affiliations. They will be politically neutral, and they must base their decision on the evidence presented by the prosecution and the defense.
And finally, Attorney, earlier you did mention that senators delaying this impeachment trial already constitutes a violation of the Constitution. But who will hold them responsible? Is it the Supreme Court? Because petitions have already been filed, but if the Supreme Court does decide on this, does give its interpretation, it is an equal chamber with the legislative body of our government, right? So there's a separation of powers. Can the Supreme Court mandate or instruct the Senate to proceed with this impeachment trial?
Well, I do not want to preempt the decision of the court, but with respect to that question, I believe there are certain petitions for mandamus already filed before the Supreme Court so that trial may proceed. But of course, for academic purposes, if the Supreme Court, the highest court of our country, issues an order instructing the Senate to, without delay, proceed with this impeachment case, then of course the Senate must follow. This does not mean that the Supreme Court is superior to the Senate. It just means that the Supreme Court, by interpreting the Constitution, which is the highest law of the land, must be followed even by a co-equal branch of the government, which is the Senate or the legislative department, rather.
All right, well, thank you very much for breaking down that process for us and for your insights. That was law professor and constitutional law book author, attorney Jennifer Arlene Reyes. Thank you, attorney.